Good afternoon and welcome to another edition of Legal Access here on WMBF News. I'm your host, Dave Priest. We get together Thursdays to give you a chance to ask questions that you've always wanted to ask about different topics of the law. Today we're going to be doing a new topic for us, I believe, talking about mediation. It's very, very common in the world of law, but something we've not really talked about. Give you a chance to ask some questions as well. The next 30 minutes is all about you, so don't be shy. If you've got any questions, please feel free to give us a call. Phone number, as always, is 843. Got to put that area code in there now. 848-8080. That's 848-8080. Give us a call here over the next 30 minutes. Mediation, that's our topic here today on Legal Access. Here on the panel to answer those questions that you might have, to my right from the McGuire Law Firm is Ian McGuire.
Good to see you, Dave.
And also want to welcome back Jay Bolts. It's been a few weeks since you've been here with us.
Yes, thank you.
Appreciate it. And we've got a first-timer to my left. Want to say welcome to Sherman Lee Kreiner. Thanks for coming in.
Thanks, Dave.
Yeah, Dave, this is a different topic. 6 years and we've never actually done this, and it's sort of interesting that we haven't, because as you mentioned, it's such a giant part of the law that we all practice. Everything really ends up revolving around mediations. We have two great guests to help us answer questions today. As you said, Jay has been with us before. Jay practices in the area of family law, does an outstanding job. He's written a book on separation agreements that's actually gone national. He's going around the country speaking about it and does a great job. But he also handles mediations, both the civil and primarily family court. And as he'll tell you, the family court mediations are becoming a lot more common, and that's a great thing. And of course, Sherman, it's great to have you with us. Sherman has mediated a number of cases for our firm. I would say for our firm, firms, a case that we're involved in, and he's with Alternative Dispute Resolutions in Wilmington, but of the Carolinas. He practices both in South Carolina and North Carolina, does a great job. He does everything from workers' comp cases to personal injury cases, and also does family code, really everything, and his practice is completely dedicated to mediations and arbitration. So it's great to have you both with us today, and then please give us a call if you have any questions regarding mediation.
Yeah, it's a wide variety. I mean, whether you've been in an accident, if you've got a workers' comp case, if you've got a family law dispute that you wonder whether or not you should use a mediator, if you should go directly to one, whether you need to go through an attorney, how the whole process works. You've probably seen it on TV where there's, a person and a lawyer on one side of the table, a person and a lawyer on the other side of the table, and there's a mediator there as well. Is that the way it works? I guess that's my question, is that I have a lot of questions about this because we've never done this topic before. So how does the whole process of mediation get started? I mean, does a lay person like me who has a case, do I say, hey, I want to pick a mediator? Does it go through the courts? How does that go?
Well, it can work that way, but as Ian mentioned, both Sherman and I do circuit court cases and family court cases, although my emphasis is on the family court, and I understand Sherman does probably more circuit court cases, civil cases. But in the family court arena, the majority of the cases that come to me are parties who come to me without attorneys. They want to bypass attorneys, bypass the court system, and go directly into a procedure in which, if they have an idea how they want to resolve their differences, they just need help with it. They need help with resolving some disputes they may have, need help with getting through the process, then they can come to a mediator such as myself and do that. However, in the circuit court cases, those cases typically involve, like you said, attorneys representing both parties at the table as well.
So does a judge say, hey, listen, before we try this case, let's see if we can get it settled with a mediator? Is that how it works?
Most cases are court ordered into mediation, and then the parties are given a period of time within which to select a mediator. If one is not selected, or the parties cannot agree on one, then the court will appoint a mediator. But the majority of the cases, when you've been doing it as long as Jay and I have been doing it, we're going to be selected by the parties. But let me back up for a minute and speak directly to your audience, that I think a lot of people have a misconception of what mediation is. And some people think it's a deposition where they're going to be asked questions, or it's going to be some type of trial where evidence is going to be put on and the case is going to be argued. or that it's like an arbitration where at the end a decision is going to be made by Jay or I or whoever the mediator is. Basically what mediation is the way I describe it to people. It's just an opportunity for the parties to get together, to talk informally, and our role as the mediator is to facilitate a negotiation or that conversation.
Right.
And I know you asked at the beginning that what you see on TV is where the parties sit down at a table and everybody's there together.
Right.
That's typically how it starts.
Yeah.
And the number one question I get asked by people about mediation or the participants is, am I going to have to talk? Because they're afraid to talk.
Right.
They can talk as much as they want or as little as they want. It's up to them and their attorneys how they handle that. But the biggest thing that's different from what you see on TV is once you have that, what we would call an opening session or the group session, is that the parties then split up as they get away from each other. And then our role is to go back and forth. And the reason it works that way is because it takes the emotion out of the conversation. Is that if the parties stay in the same room and at the table together, then inevitably they're going to start arguing. Right. And our job is to allow them to argue and to communicate through us, and therefore take the emotion out of the room, and they're in a better position to make a good decision.
If you have any questions on mediation, give us a call. 848-8080 is the phone number, 848-8080. From what Sherman's describing, and this is a serious question, do you have any like psychological training or anything like this to be able to help? Because almost you're kind of being a Dr. Phil to these people.
I mean, that's a whole other story.
I'm serious. I mean, because you have to know how to handle people.
That is an excellent question, Dave. Those of us who have practiced in family court for decades, we have worked a lot with other expert witnesses who are therapists, counselors, psychologists, because oftentimes they are involved in divorce cases. And so, yes, we do pick up on a lot of that theory and practice as to how to handle those issues. The trainings, the constant trainings that we go through to maintain our certifications have a lot of those issues that trainers come in who are from the mental health professions. Right. And so we deal with those issues quite a bit. And we are trained to recognize when certain things might be getting out of hand. As Sherman said, we do what's known as caucusing. As he described, we split people up and then we kind of go back and forth from one party to the other party. Caucusing is what we call it. And it's sort of like shuttle diplomacy. You go back and forth after the opening session. And then we'll get back together for a group session again, or maybe several times. It just depends on the dynamics of the process at the time. So but yes, it can be difficult sometimes, and a lot of professionals involved in divorce mediation throughout this country are non-lawyers. They're mental health professionals. And so we work a lot with them, and we work together in sharing thoughts and ideas as to how to handle difficult situations.
That's interesting. Yes. We'll maybe talk a little bit more about when we get back, but tell you what, we've got to take a quick little break here right now. As soon as we get back, we'll take your phone calls as well. We're talking about mediation today. If you've got a case that needs to be mediated or you think that it should, if you have any questions about the process itself, call us now, 848-8080. That's our phone number here on Legal Access. Welcome back. We're talking about mediation here today on Legal Access, taking your phone calls, 848-8080, 848-8080, along with Sherman Lee Kreiner, also Jay Bolts, and Ian McGuire. I'm Dave Priest. Thanks for watching here today. We appreciate that. Sherman, mediation, like I said, we're trying to get to the nuts and bolts about this.
So he's the nuts?
Actually, that would have been a good joke. I wish I would have done that. But as we're talking about this here today, we're trying to get down, because we've never had the topic before. Mediation. Why do we have mediation?
Mediation basically grew out of the 1970s in the federal court system. Is that the court systems were backlogged, cases were taking forever to be heard or not being heard, and it was frustrating and expensive for the parties that were involved in the litigation. And so the court systems did some studies and looked at ways to speed that process up. And so out of that study, and again, I don't remember the names of the study, the mediation process was developed and implemented in the federal court system. From there, the states looked at what was going on in their court systems, and they were having the same problems. And the state that took the biggest lead in this in the United States is Florida, and they began implementing court-ordered mediation back, I think, in the late 80s or early 90s, I believe it was. And then I know that the states, most of the states in the United States, looked at Florida as a model and then implemented that cases in the civil arenas would be ordered into mediation first to give them an opportunity to be settled. Prior to that point, the way the attorneys would resolve cases was either by phone and then having to relay the information back and forth to their clients, which was not ideal, or on the proverbial courthouse steps as they were walking into court and everybody's stressed out. The majority of expenses have already taken place. And so the best thing about mediation is that the people who are involved in the litigation, the parties, they get to participate, and they get to participate early before things kind of spiral out of control. And in my opinion, you know, when a case ends up in trial, that's usually about the worst place for the case to end up.
That ditto to that, particularly in family court, because if parties who are going through a separation or divorce can go through the mediation process, the sky's the limit as to what they can agree to. They can do whatever they want with alimony, child support, custody, visitation. However, if they go to court, the court is very limited in what it can do. And so you go to court, you do battle, everybody presents their testimony and evidence, and if the parties don't already hate each other, they certainly will going through that process. And of course, as you know, that can always affect the children. That really, truly can poison children with that kind of battle between the parents. But the court's going to order, issue an order and say, you're going to do this, 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 case adjourned, next case, you're out of here, you know, and so you're going to have to live with that for a long, long time. Whereas in mediation, the parties can determine for themselves what's best for themselves and what's best for them, their children.
But if it's a really combative situation, it might not be something they can go through in media. I mean, a lot of people, especially in family law, if they're getting divorced, one of the reasons they're getting divorced is because they can't agree on anything. So obviously, you might go in with the best intentions of being able to separate this and that, but a lot of times it'll end up, you know, going to court anyway.
Another good question. First of all, my staff will interview the parties before we get to the mediation, and in that interview process, we can detect if there's going to be serious emotional issues. And if that is the case, what we will do is we'll have one party come in first and sit in one part of the office, the other party come in, and we'll just start right out with the shuttle diplomacy going back and forth between the parties. And then when they leave, they don't see each other as well. They leave separately. And then also that brings up another issue. It's called collaborative law, which has taken hold across the rest of the country and parts of this state, and that is where attorneys will sign disqualification agreements saying that they can't take a case to court. All they can do is try and settle it, and then they will enlist the support of other professionals, including a mental health professional, to serve as a divorce coach, okay, to help the parties through the process, not for therapy or counseling, but to help get them through the process. Mental health people for working with children, for parenting coordination purposes, financial professionals. CPAs love the alphabet behind their names, and the new alphabet behind their names is CDFA, Certified Divorce Financial Analyst, because there's a lot of laws out there, particularly tax laws, that apply to marriage and divorce and separation. And then, of course, mediators as well. So there are solutions to those issues when they come up.
Now, Ian, when we started off, and we are taking your phone calls, by the way, mediation is our topic. 848-8080 is the phone number here on Legal Access. When we started off the show, Ian, you said that, you know, as an attorney that you've used Sherman before as a mediator. How does that work for you as an attorney to be sitting in, and do you sit back and let these guys do the work? Do you speak for your client? I mean, how does that all work from your end?
Frankly, it depends, case by case basis. But you know, if going back, as Sherman mentioned, years ago, 22 years when I started, everything was done on the phone with the other attorney, and you'd resolve cases, but a lot more cases back then went to trial.
Right.
Okay, because you didn't have this vehicle to resolve disputes. So if you had clients that didn't have complete trust in each other, or attorneys that didn't trust each other, or whatever the case may be, much more of the cases ended up in trial, and that frankly costs everybody more money. You know, and there are some cases that need to go to trial, and that's okay. But I don't know if it was 10 years ago, 15 years ago, but Horry County was one of the pilot counties where we had mandatory mediation. So basically, before you have a trial, you have to mediate the case, and it worked so well. And if there's a problem with it now, from a selfish standpoint, is you get young attorneys, they don't get any trial experience because it's so rare. You know, we take our case and we prepare it as it's going to trial, and that's the way you get the best optimized settlements value. But at the end of the day, it's 95% of the cases are settling at mediation.
Let's go to the phone real quick. Michael's in Conway with us right now. Hi, Michael. Thanks for calling in.
Yes. The question I have is, if you can't come to agreement in mediation, after mediation, do the case go to court, or is that the end of it?
No, and I'll let these gentlemen elaborate on it, but absolutely will not end the case. It's just a vehicle to try to settle your differences. If you can't settle at the mediation, then hopefully you'll have a court date shortly thereafter.
What percentage do you think gets settled in mediation?
My experience has been typically about 70 or 80% settle. But also, to follow up on Michael's question, is that as mediators, we try to resolve the whole case and try to get complete resolution. And I'm sure Jay does this as well, is that if it's at some point appears that the case is not going to settle, then you take fallback positions of what issues can we resolve for the parties. Can we avoid trial over some of these issues? And depending on what cases there are, sometimes you can avoid